mitigation of damages. Mitigation of damages comes to expectation damages in the following way. Expectation damages are calculated by the loss in value plus the other loss, which can be consequential and incidental losses, minus any loss avoided. And there is, as we'll see, a duty to avoid loss whenever possible. This is also referred to as not piling up damages. The second restatement of contracts, section 350, says damages are not recoverable for loss that the injured party could have avoided without undue risk, burden, or humiliation. This is often referred to as the duty to mitigate damages or the duty not to pile up damages. To put it another way, the injured party can only recover for only unavoidable loss. Why is this the correct rule of law? Well, let's first consider an illustration to understand better what it means to mitigate damages. Let's imagine Lucy buys a bunch of apples, 50 fresh gala apples, from Morty for $50. Now, as we all know, one bad apple spoils the bunch. This is actually because a spoiled apple releases certain gases, the other apples react to that gas, causing the others to ripen. And so what happens if Lucy discovers one of the apples is spoiled in the bunch? If Lucy's removal of this one apple would prevent the other 49 from spoiling, she has a duty to mitigate those damages by removing the spoiled apple, and therefore she can only recover $1 in damages. If she were to leave the one spoiled apple in the bunch, causing the rest to spoil, her damages would be $50. All of the apples would have been lost. They would have all spoiled. But she has a duty to mitigate damages, and she could have done so quite easily by removing the one spoiled apple. And so the correct measure of her damages is not $50, but $1, so long as she was reasonably able to mitigate the damages by removing the spoiled apple from the bunch. Lucy has a duty to mitigate damages, and when she fails to do so, she can only recover damages she would have avoided without undue risk, burden, or humiliation. The restatement gives a similar example. It says, A sells oil to B in barrels. B discovers that some of the barrels are leaking, in breach of warranty, but does not transfer the oil to good barrels that he has readily available. B's damage for breach of contract does not include the loss of oil that could have been avoided by transferring the oil to the available barrels. The principle is the same. So long as it was not unreasonable for B to mitigate the damages, B cannot collect damages for harm that B should reasonably have mitigated. B has a duty to mitigate damages. The reason for this rule should be clear. The duty to mitigate damages encourages people to prevent things from becoming damaged. Once again, we see how the general purpose and first principles of contract law are served by these specific rules. The overall purpose of contract law is transferring the allocation of resources to the place of highest value. This would not be served by paying someone for allowing a perfectly good resource to be destroyed. The purpose of contract law is to facilitate the transfer of resources to their place of highest value because doing so makes the world better off. The world is better off when resources are preserved and not destroyed. So the common law of contracts has evolved to require parties to preserve the value of things when doing so is reasonably possible. A more specific application of this general duty is found in the Uniform Commercial Code duty to cover. Cover means obtaining specific substitute performance. Cover means obtaining substitute performance. For example, imagine that Nancy hires Oscar to be her personal chauffeur driver for a year and will pay him $100,000 for a year of chauffeur services. Let's further assume that Nancy, lives in New York, and so she never got her driver's license. So she needs Oscar to get her to work at her high-paid corporate executive job, where she earns $1 million per year. So she needs to spend this $100,000 to earn $1 million. After 6 months, Oscar quits. If Nancy does not replace Oscar, she'll be fired and lose her salary. Does that qualify as consequential damages? Can Nancy recover $500,000 from Oscar in consequential damages because his failure to drive her to work caused her to lose $500,000 in income? No, she cannot, so long as she could reasonably replace Oscar. Nancy cannot simply stop going to work and sue Oscar for $550,000. She has a duty to mitigate these damages. She must hire another driver and continue going to work. But the duty not to pile up damages may seem simple. It is in fact more complicated than it seems. For instance, can Nancy hire a cab every day? Does she have to get a new chauffeur? Let's assume that it's more expensive to hire a cab every day than a chauffeur for a year. Does Nancy have to hire a new chauffeur for 6 months, or can she hire cabs every day? What constitutes a valid substitute performance? Nancy will be able to recover the difference between how much she would have paid Oscar and how much she would pay a different chauffeur. But can she recover the difference between what she would have paid Oscar and what she actually pays in taxi fare, where taxi fare is more expensive than chauffeur service? If Nancy hires a cab driver every day, she may pay more for this series of short-term spot contracts than she would for a longer-term contract for chauffeur services. Does this create an obligation in Nancy to enter into a new, cheaper, long-term contract, or can she cover with more expensive short-term spot contracts? Generally, the injured party may choose between covering with short and long-term contracts. In fact, the Uniform Commercial Code section 2713 specifically states this is the case with regards to sale of goods, stating, quote, "The measure of damages for delivery or repudiation by the seller is the difference between the market price at the time when the buyer learned of the breach and the contract price, together with any incidental and consequential damages, but less expensive saved in consequences of the seller's breach, loss avoided, and where no market price is available, evidence of spot sale prices is proper." The duty to cover is not the only limitation in expectation damages. As we'll next discuss, an injured party cannot recover for unforeseeable or speculative losses that are difficult to prove. But before we move on, are there any questions about the duty to cover or the duty to mitigate damages?